Fantastic. So, Barbara, would you like to start with an introduction about the E&E, etc., and then I will the bios of the speakers?
Yes, of course, sure. Okay, so I would like to welcome all our students, of course, and all other audience that is listening to us live right now. We are meeting here within the framework of the Employment Network event, which is an employment network event organized by international and European law program at the Hague University of Applied Sciences for many years due to fantastic work of many colleagues from law program, including Aurélien Lorange. And I would like to thank our panelists for joining us today, but also Dr. Maliaropoulou for putting together this wonderful panel of practitioners in international arbitration and our alumni. So now I give you, Artemis, the floor to introduce those fantastic speakers today.
Thank you. Thank you very much, Barbara, for your introduction and for your kind words. Our speakers do not really need introduction, but I will simply try to summarize the main stations of their exciting journeys. So I will start with Lisa Wanklahovic. Lisa is an associate in the litigation department and a member of the International Dispute Resolution Group of Debevoise and Plimpton, and she's based in New York. She received a JD from Yale Law School and an AB cum laude from Harvard University. She is an attorney admitted to practice law in New York. Her practice focuses on international commercial and investor state arbitration and public international law. She has experience arbitrating under the ICC, AAA, ICDR, and exit rules. For those of you who may think that big law is a synonym of obsession with big clients and nothing else matters, Metallica know better, not really, then please think twice. Lisa co-authored the War Manifestos published in 2018 by the Chicago Law Review, which was one of the first, and if I'm not mistaken, the only one paper that scrutinized more than 350 documents from all over the world that set out the legal reasons sovereigns provided for going to war from the late 15th through the mid-20th centuries. Furthermore, she is a recipient of the 2019 Above and Beyond Pro Bono Achievement Award from Sanctuary for Families and the 2018 Safe Haven Award from Immigration Equality. Besides representing clients in multi-million and multi-billion disputes before arbitral tribunals, she has been involved in numerous pro bono projects, and the latest one is the one related to the contribution of Debevoise and the Public International Law and Policy Group to International Criminal Court Prosecutors' Gender Persecution Policy Initiative. And we will learn more about this during our discussion. Moving to our next panelist, Camille Ramos-Claire. She is an independent tribunal secretary and a New York qualified attorney based in New York, who focuses her practice on international, commercial, and investor state arbitration. She works closely with several arbitrators based in the US mainly, and has worked on arbitrations conducted under most major international rules, including UNCITRAL, ICC, and ICDR. She holds a JD from Boston University School of Law and a BA from Amherst College. Before her decision to move solo, Camille worked as a legal fellow at New York University's Office of the General Counsel. Camille is active in several professional associations related to arbitration. She is a member of the Arbitration Committee and an affiliate member of the Inter-American Affairs Committee of the New York City Bar Association, a member of Arbitral Women, and an ambassador of the Arbitrator Intelligence. She has also participated in mentorship programs offered by the Young Institute of Transnational Arbitration, the Spanish Club of Arbitration, and Arbitral Women. Once again, if you think that international arbitration practitioners are one-dimension human beings who do not care about the welfare of the society, At least think twice. In addition to her work in the arbitration arena, Camille serves on the executive committee of the Leaders Young Professionals Board for Latino Justice, a nonprofit dedicated to defending the civil rights of Latinos in the US. Our next panelist is Dimitra Takiri. Dimitra is a deputy counsel at the International Court of Arbitration of the International Chamber of Commerce based in Paris, where she is involved in the case management of commercial and investment arbitration cases conducted under the ICC rules for arbitration. Before joining the ICC, Dimitra worked in international arbitration groups of prestigious law firms in Austria, Switzerland, and Greece. Dimitra has experience in the construction, sale of goods, energy, and gaming sectors. She has advised private companies and states in proceedings under the ICC, ICSID, VIAC, DIS, and UNCITRAL rules. Dimitra is a qualified attorney in Greece. She obtained her law degree from the Faculty of Law of the National and Kapodistria University of Athens, and her LLM specialized in international dispute settlement from the Graduate Institute of International and Development Studies and the University of Geneva Law Faculty. Dimitra is an active member of ASA Below 40, Young ICA, LCIA Young International Arbitration Group, and she is one of the founders of the Greek ARB Forum. ASA Bulletin published in 2018 her paper on the application of the New York Convention to the enforcement of arbitration agreements. I need to disclose that she participated in the Vismut in 2015, and this is when I met her, and received an honorable mention as an individual oralist. Besides her international arbitration work, she belongs to the category of inspiring lawyers mentioned before. So her volunteer work is something that is not widely known, but I have been impressed with her commitment to the most vulnerable groups of the society and her involvement as a volunteer in the Special Olympics. Now turning to Andra Ioana Kurutu. Andra is one of our fantastic alumni. She graduated from the International and European Law Program in 2021. During her studies in The Hague, Andra developed a strong interest in international arbitration, particularly throughout her work with Arbitras. Arbitras is a student-led ADR community based in The Hague. As a podcast coordinator for Arbitras, she organized podcast sessions and webinars with alternative dispute resolution practitioners and scholars from Switzerland, the Netherlands, the United Arab Emirates, and Nigeria. She is currently an LLM candidate in international commercial arbitration at the Stockholm University. This year, Andra was one of the members of the team that successfully represented the Stockholm University in the Vismut competition. She also competed in the annual Conrad Arbitration Quest, where she gained the award for the first runner-up. Andra is also a young ITA mentee and an assistant editor for the Stockholm University International Commercial Arbitration Law Alumni Association publications. Now turning to Professor Dr. Barbara Varvas. A very short summary of her achievements. Barbara is a professor of law at the Hague University of Applied Sciences, and she is the head of the Global Governance Research Center. Barbara is the founder of the minor in dispute resolution of the law program. Prior to this position, she was a coordinator of the comparative law line and commercial law specialization of the law program. Barbara is the author of The Liability of Arbitral Institutions, which was published by Springer in 2016. Before that, she worked as a drafter, researcher, and administrator for the study on the legal instruments and practices of arbitration in the European Union and Switzerland, commissioned by the European Parliament. Barbara has a PhD in law from the European University Institute, and prior to joining the Hague University, Barbara worked as a visiting counsel in the litigation department at the General Electric Oil and Gas in Florence and in the Italian law firm Studio Legale Calabresi Guadalupe. And last but not least, a big thank you to Alexandra, who is a very dedicated ADR student at US, who will help us in the context of moderation of questions we will receive via WebEx and YouTube. Now I am moving to the first question. quickly. So we would all like to learn more about the beginning of the journey. So for our fantastic panelists. So was international arbitration your ambition from the very beginning of your legal studies? It was an informed choice or to a certain extent a serendipity outcome? And let's start with Lisa. So you have the floor.
Thank you so much for the introduction. It's great to be on this panel with the rest of you. I'm happy to discuss kind of why I landed here at Debevoise and working on international arbitration. I guess I've always been interested in global affairs and world history. I did Model UN as a high school and college student. So coming to law school, I kind of gravitated toward the international courses, and fortunately there were very many arbitration courses that I took advantage of. Theoretical courses, but I have to give credit to the arbitration advocacy course I took, which culminated in a mock hearing in lieu of a final exam. Really great kind of hands-on experience as to what it's like being an arbitration practitioner. I think the final case was Brady versus Bunchen, so it was a U.S.-Brazil kind of commercial arbitration dispute. So I had a lot of fun. So when we were doing the kind of interview process for law firms, I looked for law firms who specialize in international arbitration. Debevoise is, of course, one of the top ones, and loved it here. And so came here kind of right after law school and dove right into arbitration practice.
Thank you. Thank you very much for sharing your story with us. And I'm glad to hear that the starting point was something from the university, and I see it is nice to see that inspiration comes from our studies as law students. So thank you very much for that. And Camille, would you like to share the beginning of your journey with us?
Sure. So for me, I really took the roundabout way to arbitration. I think describing it as a serendipitous outcome is probably the best descriptor there. So for me, I went into law school really thinking I wanted to do immigration work. So for me, I'm Peruvian American. I'm the child of an immigrant. And I wanted to be in a field where I could take that kind of cross-cultural understanding that I'd been raised with, as well as the language skills. I grew up speaking Spanish at home. And I thought immigration would be the best way to apply it. But when I worked my first summer after starting law school at an immigration nonprofit, I found I enjoyed the work, but the emotional toll was, I think, a little bit too much, especially just having that personal connection there. So I started looking into alternative practice areas. I looked at business immigration. And by chance, when thinking about, well, what are ways I can apply these skills that I've been raised with, that I've had, I ended up taking international business arbitration during my second year of law school with Professor William W. Park, better known as Rusty Park, who at the time I was not aware was one of the most prominent North American arbitrators. And I really enjoyed the course. I kind of fell in love with the topic. So I started working as his research assistant while at the same time doing a summer associate position at a business immigration firm. And when I graduated, he started giving me work as a tribunal secretary, which is kind of how I began to learn about the role. But at the same time, I was trying to figure out also other fields. As Artemis mentioned with the introduction, I was doing a legal fellowship at the same time at NYU's Office of the General Counsel and had the chance to learn about several different practice areas. So I wasn't sure about the viability of staying in the arbitration field as a tribunal secretary. So I started going to a lot of networking events just to explore different practice areas. And by chance at a Women in IP event, I ran into an international arbitration associate at a firm who was familiar with another tribunal secretary who was making it work, who knew how everything operated. And by speaking with her, by kind of getting her advice on what I should be billing, what I should be doing, how exactly I should prepare, I ended up making the decision to fully transition into solo practice as a tribunal secretary. And we'll get into mentoring and networking later, but that really kind of shaped my career at that point.
Thank you very much, and thank you for highlighting the importance of meeting the right mentor from the very beginning, either an informal, in the context of an informal mentorship scheme, or a formal one. So thank you very much for that. And then, Dimitra, would you like to share with us your journey, how it all started?
Yes, thank you very much, Artemis. Well, my story, my arbitration journey starts like many others from my participation in the Vismut competition, where one day at the university I saw a call for interest for students who want to represent the University of Athens in this Vismut competition. And I said, I mean, I did not know, back then I did not know a lot about arbitration. I just knew a few things about ADR and mediation. But I thought that it looks like an interesting international experience. And I mean, at the end of the day, it's a free ticket to Vienna, so why not? So this is how I applied. And during my participation in the Vismut, that was my first contact with arbitration. I realized that arbitration is really a field sort of without borders, a field that allows you to practice law wherever around the world, and a field which allows you to learn a lot about different industries. So this is exactly what excited me about arbitration. So when I graduated from the University of Athens, I contacted one of the law firms that assisted us during the preparation in the Vismut and asked to train with them. I knew that they were also having a few arbitration cases, so I wanted to get hands on a real arbitration case and see how this works in real life. And this is how I got involved in my first construction arbitration case, where I also attended my first hearing. And I have to say, construction arbitrations are not an easy task. But nonetheless, I did not get discouraged. I was actually excited even more, and I wanted to learn more about this field. So with the help of my mentor, Professor Gourgourinis at the university, I applied to the MIDS LLM in Geneva, an LLM on international dispute settlement, where I expanded my knowledge on commercial and investment arbitration, also on public international law. And during my MIDS LLM, I participated in various events where I met my future employers. One of them was in a partner in a law firm in Geneva, where I did a 6 months internship after my LLM, and I got the chance to get involved in my very first investment arbitration as well. From Geneva, I moved to Vienna, where I landed an internship there through a contact that I made during a networking event. That was a partner who had a law firm in Vienna, which specialized also in arbitration. And there I converted to an associate after giving my bar exam in Athens in the meantime. There I had the chance to interact with a lot of clients, prepare witnesses, draft submissions, get involved in both commercial and investment cases. And after 2 very fruitful years, I would say there, I decided that I would like to also gain an insight on how an international organization, an international arbitral institution works. So I applied for the deputy counsel position at the ICC in Paris. And because of my background with Austria and my German language skills, I got a deputy counsel position in the German-Austrian team, which also has cases involving other regions. I'm basically currently administering about 80 arbitration cases, mostly commercial arbitration cases. helping the users of arbitration, arbitrators and councils to apply the ICC rules. And I'm also representing the ICC externally in various events, such as the one today.
Fantastic. Thank you. Thank you so much for sharing your input. And I see that there are some common things. So the importance of mentors from the very beginning. You mentioned Professor Gurgurini's Vismut, again, which is a starting point, or a number of moot court competitions or activities inside the university that are related to advocacy and arbitration and networking. And we will return to this point with questions. I'm pretty sure about that. And I couldn't agree more that construction arbitration is, I mean, for me, it's like a thing that you start with a dictionary. What is this? I cannot understand the one word. Great. Thank you. Thank you very much for that. Then I'm moving to Andra. Andra, what is perhaps the thing, the cause, what is exactly that attracted your interest to international arbitration, and you decided to continue with postgraduate studies exactly after your graduation from your LLB?
Thank you very much, Dr. Maliaropoulou. And I would also like to thank Ms. Mihaela Tarnowski, who is the team leader of Arbitras, the student-led association in ADR at the Hague University. And I'm very happy to be talking today on behalf of Arbitras, since it was actually Arbitras that raised my interest in alternative dispute resolution and, more importantly, international arbitration. I also started law school, and I came to The Hague with the idea in mind that I would do human rights and diplomacy and work for the United Nations. I also did the Model United Nations during my studies, and it was during Model United Nations that I realized I'm very interested in mediation and conciliation. But at that point, I was only interested in them from the perspective of public international law and diplomacy. When I saw a call for Arbitras, and what Arbitras is doing and their role in promoting alternative dispute resolution and mediation as well, I immediately applied, and I ended up working as the podcast coordinator. Little did I know that during Arbitras, I would develop a very strong interest in international arbitration, and especially international commercial and investment arbitration. I conducted some podcasts with arbitration practitioners in the field. And it seemed to me, exactly as Dimitra said, that it is a field without borders. It is a field that encompasses so many different aspects, and you can move everywhere. You can work with it in different arbitral institutions or law firms or even UNCITRAL. And for me, that was something very important, to have this wide area of choosing in the future. So that is how I ended up in international commercial arbitration, and I started this path. Afterwards, I took the alternative dispute resolution at the Hague University, which further reiterated my passion for the field, and now I'm doing my master at Stockholm University.
Thank you. Thank you very much for sharing your views, your enthusiasm, and for highlighting the role of student associations, because sometimes we underestimate the power that students have, even on an undergraduate level. So thank you very much for that. So now I hand it over to Barbara.
Thank you so much, and thank you for your presentations. Really interesting. I would like to now to zoom out a little bit, although we will move back to your individual careers. The third question, I believe. So zooming out, Dimitra already mentioned that arbitration is the field without borders. And I also remember when I was an intern at the ICC, and I was sitting in the big room at the meetings, weekly meetings, and then the meeting of the court. And it was so fascinating for me that people can, private actors can do private justice in a way. My question is, what is so exciting about arbitration? Maybe those who are listening to us know about arbitration, but maybe they don't know that much. So in your view, what is one particular issue or a puzzle now in the arbitration field, but maybe which is also important for the society at large or the parties, how you see one particular issue now in arbitration that is of seminal importance within the field and beyond. And maybe I could start with Dimitra.
Thank you very much. Indeed, what I personally like about arbitration, apart from the fact that it does not have borders, it's also the flexibility that it offers to the parties to make the dispute resolution process, to make it suitable to their specific dispute. But apart from that, what I also consider very interesting in the field of arbitration is also the fact that it opens the door to lawyers, and I'll speak from the lawyer's perspective, to study different industries and different sectors, so to say. And I have observed in late years that young arbitration practitioners sort of over-specialize in the procedure of arbitration as such. So they sort of exclusively and excessively specialize in procedural arbitration issues. But what matters also is that the dispute takes place in a specific sector, in a field, and it's important to also sort of be able to grasp all the details of different sectors and be able to make a convincing story for your client, because at the end of the day, what matters is not so much the procedure as such, but also the specific sector. So there's this over specialization in arbitration. I mean, it's very important to know the process as such, but I also believe it would be very interesting to get an expertise in specific industries. And so far, I've seen very interesting industries at the ICC, such as air and space law, hospitality, aviation. And at the ICC, when sometimes when we are called upon to look for arbitrators, we really look for arbitrators who also, of course, have the knowledge of procedure, but also have knowledge and specialization in specific industries. And this is something that I would like to highlight, so to say, apart from the procedural aspect of arbitration.
Thank you so much. So I think we should be kind to our students on the procedural aspects of arbitration. We will keep it in mind too. Camille, would you like to take the question up?
Sure. So for me, one aspect of arbitration I found fascinating, and I guess this was a little previewed in my first response, is kind of the cross-cultural connections there. I know with the Vismut just now, when I was arbitrating rounds, my friends who are in different practice areas were astonished that at one night I could be arbitrating a round between a Brazilian and Japanese team, and the next it would be German and Nigerian. And just kind of the way that arbitration, and especially international arbitration, can make the world feel smaller. And in that vein, kind of, I've been really inspired by diversity movements within the field too, since traditionally, especially kind of with the emphasis in the US and in Europe, the field hasn't been as diverse as it should be. There hasn't been that reflection of various cultures in various countries. So for me, I'd be remiss here to not mention the work that Arbitrator Intelligence is doing. I know as an ambassador, there's a bit of an obligation there, but for them, they're a startup that's really dedicated to collecting information on arbitrators through anonymous surveys, through phone calls, and generating reports that law firms or interested actors can purchase. Just because when you appoint arbitrators, generally you would be calling around to friends, to people who've appeared before that arbitrator. But if you're an entrant into the field, if you're just dipping your toe into arbitration, you're not necessarily familiar with the wide range of arbitrators who are available. And so it really has increased access in that way to arbitrators who might be very well known in their jurisdictions, but on an international stage don't necessarily have that recognition. And I know especially with Latin America, there's been a bit of a frustration too that you'll sometimes have arbitrations where both parties speak Spanish, all the documents are in Spanish, the council speaks Spanish, and then they appoint 3 arbitrators who don't speak Spanish. So you spend a lot of time on translations and time and money as well. And so just being able to bring up arbitrators, especially younger arbitrators too, has been really a great diversity initiative from Arbitrator Intelligence, among other aspects too, which it's devoted to raising transparency as well.
Sounds really great. I think there's still quite some work to be done on the side of diversity, but indeed, I think we are moving into the right direction. And also the fact that we have so many female participants today, only female participants having so many different roles in arbitration, I think it's also a very good representation that the field is indeed changing. All right, so I would like now to hear Lisa's view on these bigger arbitration issues.
Great. Yeah, I would just like to echo that. Very thrilled to be on this panel of women here. Very inspiring and young women as well. So kind of one of the puzzles that I'm really seeing in my practice lately is kind of the balance between courts and tribunals, and who has the power to decide and when, and both at the front end of arbitration with looking at whether the tribunal has jurisdiction, and also at the back end when you're looking at award review. And we see this in Europe with the Acmea decision. The courts are taking a more active role in looking at whether the award was valid, if it's under an intra-EU investment treaty. In the US, there's a lot of debate and uncertainty in the law about kind of the who decides issue. So if the arbitration agreement isn't clear on whether the tribunal decides its own jurisdiction, when and how can courts intervene to injunct an arbitration, or conversely to compel an arbitration. And this was kind of a major case I was working on the past 2 years for one of our clients who was served with a second arbitration request from the same claimant. We went to the Delaware courts to seek an injunction of that second arbitration on grounds that it was a collateral attack of the first award under the US arbitration statute, the FAA, Federal Arbitration Act. And actually that case progressed from the Delaware Chancery Court to the Delaware Supreme Court, eventually to the US Supreme Court. We briefed the cert petition and we prevailed. And so in that case, usually, Debevoise is usually the party saying, let's go to arbitration. But in this case, we actually, convinced the courts that, they had a role in protecting kind of the sanctity of an award that was already issued and duly passed into judgment and paid and everything. And so under the US arbitration statute, it is the role of the courts to kind of protect that award from a second attack, whether that attack comes through litigation or arbitration. So it's a really interesting, fascinating issue. I think the balance between courts and tribunals, I think we're seeing a lot of variation in different jurisdictions in terms of how much intervention is appropriate. And so it's a really, I think, topical puzzle that we're seeing in the arbitration field.
Very interesting. Myself and Artemis were also involved in a trial project on independence, impartiality of arbitrators and judges. And we were also discussing how this looks in Europe, whether we have a similar regime for arbitrators than we have for judges. And I think what you were also speaking about, despite the more procedural aspects and how they matter for arbitration, I think it would be also interesting to know from you how this looks like in the US, although I believe in the US, arbitrators are also considered as quasi-judges, and it's different than it is in Europe, because here they are more considered service providers. But just 2 cents from our also project, most recent project, and I would like also now to give the floor to Andra.
So for me, that's actually a very interesting topic, because today I just found that the topic of my master's thesis is a bit of a hot topic nowadays in international arbitration, and that is because of the war between Ukraine and Russia. And I'm writing my master's thesis on the power of arbitral tribunals to revise the price in long-term energy contracts. And this is very important now because of the sanctions. And as a result of the sanctions, the price of gas and other energy products has increased. And there will be a question whether arbitral tribunals can revise the price. And this is particularly important since parties that are from Russia are not, it's not necessary for them to go to arbitration anymore as a result of the decision from the Russian Supreme Court a couple of years ago. So I believe that the war between Russia and Ukraine does have, without any doubt, humanitarian aspects, but it also has the commercial aspects, and its effect on arbitration should be taken into consideration.
Thank you so much, Andra. So many topics. I hope that our listeners got also inspired. I'm sure they did. And now the floor is yours, Artemis.
Thank you very much. I am keeping notes, and I think that we could continue the Q&A session forever. So thank you so much. But I will step back from the substantial part, and I would move back to something substantial but more related to your journeys again. Your paths are quite of course, very interesting, but different from what we expect. And they are a very good and the ideal proof that there is no one size fits all in international arbitration. So it's not a field that you know that there is only one thing you can do. Let's say I want to be a notary public. There is only one way to do this. There is only one field, nothing more I can do. So if I may start with Camille. Camille, I think that you followed a non-conventional path in international arbitration, and you decided at a very early stage to establish your own brand as an independent arbitral tribunal secretary. My first reaction was that there must be some challenges there. It must be difficult for a young woman to do this. So would you like to share with us some of the challenges that you had to face? But at the same time, what was for you the most exciting part of this journey? So what was the main opportunity that it offered you? I don't know, it could be flexibility or variety or anything. And you said that I will follow this path and not another one. Thank you.
So kind of my original decision to practice solo, I'm not sure if it was entirely voluntary, I guess, because I was doing the legal fellowship at the same time. And so I really needed the flexibility to be able to set my own hours, set my own schedule when I was doing arbitration work, because it just wasn't really a viable option that, okay, well, I can take time off during the day during my other job. But as I moved on from that after my fellowship ended, kind of the flexibility remained a big perk. And of course, there were challenges because when you're solo, I realized after about a year that the only person who could really vouch for my work was Professor Park, because I was working with him directly, occasionally other tribunal members, but really just one person. And that I had a huge need to build my network because my colleagues who were in big law at arbitral institutions were building their network more organically through their work. And so those were kind of the challenges in the beginning. Now that I'm working with several arbitrators, so I've because of that networking, I've really been able to get more clients than just the original arbitrator I was working for. It's really helped me avoid conflicts, in that I found that my colleagues who are at similar levels can end up getting conflicted out, or even more senior. I know that for senior arbitrators at law firms, they often have the frustration that, okay, I can't take this matter because we might be taking on this party as a client eventually. So I've really been able to avoid, unless there's a conflict with one of my other cases or a personal conflict, I'm really able to take on as much work as possible. So in that way, practicing as a solo has been a huge advantage, because I'm avoiding all of these issues that come up from being in kind of a bigger firm or having other people do work that's not related to yours, but that might create conflict.
Thank you very much for elaborating on that. Thank you. But it is a fascinating choice. Thank you for that. Then, if I may move to Dimitra. Dimitra, you started as a lawyer qualified in one jurisdiction. So how difficult it is for a young lawyer, again, a female lawyer, I think it still makes, I think that perhaps not for so young practitioners now, and I'm very happy to see that, but at some point, some years later, it was not that easy. But in general, how difficult it is for you to move to a new jurisdiction and then to another jurisdiction. What were the main challenges that you had to face? That is the first part of my question. And the second one, now that you decided to work for an institution, how do you compare the work for this institution with the work in an international law firm? What are the main differences that you would like to describe for us?
Thank you, Artemis. Well, the first part of the question, moving from one jurisdiction to the other, was something that I wanted when I started working in arbitration. I saw it as a challenge. But of course, it's not easy. Geneva was, so to say, I felt that it was a more international environment with a lot of expats, which also helped me feel more comfortable, even in the working environment. And working as a female in a bigger law firm, so to say, I mean, not only as a female, but as a young lawyer, because it does not necessarily have to do with the gender, I felt that it's not easy to be heard, sort of, because there are many layers of lawyers until I reach the person who makes the decision who's hired and who's not hired. And this is also something that I took into account when I ultimately moved to another jurisdiction to work to a smaller, so to say, boutique law firm in arbitration, where I felt that it would be easier for me to sow my passion in arbitration, my skills, and work directly with someone who would decide who would be hired or not. And I thought that it would be easier for me to convert there, so to say, from as an intern to become an associate. Of course, moving to Vienna was not an easy choice because I did not know anyone there. I started from scratch. I did not have friends, and I had to be patient and work little by little to build a life there. And once I built a life there, I decided to leave again a country and go to another one, come to Paris, where I already had connections, which also helped me to adapt more to this new country and new city. And I decided to join the ICC, where I have to admit that the work is completely it's different from the work of a lawyer in a law firm. And the first difference that comes to my mind is, first of all, the type of work. So we do have a lot of legal work, which concerns providing a legal analysis to the court, preparing the agendas. But also a part of our work is very administrative, managerial, and it's also oriented we focus also to the financial aspect of the disputes. And another big difference is that now I'm working with 80 cases. I have to administer 80 cases, whereas in a law firm I had, I think, no more than 4. So, of course, we view the cases from a completely different perspective. So at the ICC, we do not delve into the substantive issues in the same way a lawyer would do when representing a client, but we need to know at all time for all the cases at which stage they are, what is the financial situation in each case, what decisions that we need to invite the court to take, and so on. Another difference is that I have a lot more deadlines to monitor at the ICC. In the law firm, I had specific deadlines that concerned my cases, but now we have weekly deadlines to meet, and also we need to monitor the deadlines of each specific case, something that requires organization and sort of to set priorities. And the final difference that comes to my mind, and the biggest, is the exposure towards the arbitration community. I feel that at the institution, at the ICC, the chances for exposure are bigger. And this is not only because I participate more often to events and give lectures to universities, but it's also during the day-to-day work with arbitrators. We speak on the phone, we exchange correspondence, and sort of that helps a lot to build a bigger network in the field.
Thank you very much for your answer. When it comes to the first part, I think it's really fascinating that we should not forget the human nature. So it is important when you move to a new country to try to create an environment where you will be safe, you will have your friends, you will have connections. And it is a difficulty that a young practitioner is dealing with when she's moving from one place to the other. And it takes some time usually to establish a network. So this is a very important factor. And when it comes to the description of the differences between these two different fields of work, they are quite sharp differences. So thank you for sharing this with us. Thank you very much. Now, Lisa, may I turn to you, and could you please describe for us some basic aspects of your everyday work in a big international law firm, and how it is possible, how it is humanly possible to combine the billing hours with pro bono work and with significant pro bono work?
Of course, yeah, I'm happy to discuss that. And so one of the great advantages of being at a law firm is just the resources and the training they invest in young lawyers. One of the reasons why I chose Debevoise in particular was that I saw kind of the dedication to pro bono. As a law school student, actually, I was a member of a clinic that co-counseled with Debevoise on a education advocacy Supreme Court case in Connecticut, which I really got to see firsthand the dedication to pro bono. And it really, it's just a matter of kind of firm culture and firm policy as to treating pro bono work the same as billable work, and managing deadlines around all of that, especially as a young lawyer where you need pro bono work to kind of develop skills, oral advocacy skills, et cetera, that you really get to develop into your own as a lawyer by doing pro bono work. And so fortunately, a lot of the pro bono work I do also overlaps with my practice. During the introductions, you mentioned the commentary to the International Criminal Court. This was a recent commentary we published along with the PILPG, Public International Law Policy Group, a number of other law firms working pro bono as well. We basically commented on the Office of the Prosecutor's gender persecution policy, made some recommendations about how the prosecutor and the court should approach gender persecution crimes, how they should charge them, how they should involve victims at every stage, especially when it comes to deciding appeals, how they should kind of substantively look at gender persecution crimes in terms of international law and not by reference to local customs and culture. So this was a really fascinating pro bono project that also kind of developed my skills as an international lawyer at the same time. And so in addition to that, I also advise a human rights organization when they receive judicial requests for assistance from foreign courts, international courts. So again, I'm learning about the procedure, the rules, and also the substantive past cases of those. This kind of process really lets me develop client interaction skills, develop advocacy skills that I get to apply to my work, my billable work as well. And so it's harmonic. It's not kind of a tension between the two. I think it's really each kind of work really enhances the other aspect of it, and so it's a great opportunity to do so.
Thank you very much for pointing this out, because to the mind of some students and young lawyers, it's like that this is a tale of two cities. You cannot work in a big law firm and at the same time be involved in this type of project. So thank you for shedding some light and motivating people that they can do both. So thank you for that. And moving to Andra, Andra, as an LLM candidate, what are the challenges that you think you're facing now that you're embarking upon the first steps of your journey in the international arbitration arena? And how important do you think they are, the different mentoring schemes that are out there, either the formal ones or the less formal ones? Thank you.
So starting with the challenges that I face, I think one of the main challenges that I've been facing, but I also believe this is a very particular challenge to my educational background and situation, is the fact that I don't have a bar exam yet. So this year I really tried to figure out where would I go to do my bar exam, since I couldn't do it in the Netherlands because I don't know the language. And most of law firms do require the students have a bar exam. So I've decided that I'm going to do it in the UK and become a lawyer in the UK, especially because UK is very popular in international arbitration. But in my experience, a bar exam is one of the main considerations and that law firms ask for. And unless you have a bar exam or unless you are in the process of getting your bar exams, I believe that your chances of getting employed are significantly lower. And the second challenge, maybe it would be related to language barriers. I speak Romanian because I'm originally Romanian. I speak English and I speak Spanish and a little bit of German, but I do not speak French. And in international arbitration, I also know that French is very popular, especially in Europe, because Paris and also Geneva are very popular seats of arbitration. And I believe definitely language skills are one of the most important tools the student can acquire for a career, an international career and an international career in arbitration. The more skills, the better, I would say. Now, coming to the second part of the question, I believe in general that every extracurricular project, every mentoring program that you do can help you and add up some skills to your background and experience. In general, ever since high school, I always try to get involved in extracurricular projects, the more the merrier, and try to gain the skills and try to develop my knowledge. I am currently a mentee in the Young ETA program, and I'm going to post in the chat some mentorship programs that I know about or some projects that I've heard or I've been involved in. And I believe that mentoring programs have two main advantages. First of all, they give you the floor to networking. Arbitration is ultimately a small field, and even though there are so many law firms around that do it, most people know each other and most people had contact with each other because it's still a very specialized field. And mentoring programs can set your foot into the ground to meet people in arbitration, to see what arbitration is about, and to discover whether you want to do arbitration and how do you want to do arbitration. And I believe that the second advantage of a mentoring program is the fact that you get the chance to discuss with people issues in relationship to arbitration and discuss how do people from other jurisdictions see these issues, how do people assess these issues in their own jurisdiction. During my master program, I had classmates from all over the world, and we had a chance to discuss different issues in arbitration from different perspectives. So I believe that this aspect of mentoring program is also very important because it broadens your perspective and makes you understand issues from different views. Now, with that in mind, I also believe that other extracurricular projects and student organizations, and I have to admit I'm biased, so I will talk a bit about Arbitras if you'd allow me to. Arbitras really does promote the use of arbitration, and in addition, it also promotes the interest of students in arbitration. And they have different projects, including blog posts, podcasts, and newsletters, which run bi-monthly or monthly. And for students, especially at the beginning of their careers and during their studies, I believe it is important to get published, to actually research in arbitration and to show that you are interested in arbitration. And I believe Arbitras in particular is a great tool for students to us to do so.
Thank you. Thank you very much for sharing your perspectives, challenges, and tips at the same time. So thank you. Thank you very much for that. And now I hand it over to Barbara. Thank you.
Thank you so much, Artemis. So indeed, I think it would be a nice bridge with your thoughts on the third question. So we hear very often from our students questions of the following sort. So how to build my network in arbitration, how to get some visibility, where should I do my degree, where should I do my LLM, what's the best path to take. For international students, what Andra also mentioned, if I'm an international student, where should I also qualify? Shall I try to qualify in the place where I'm studying right now? Shall I go back to my home jurisdiction? How to bridge the gap between my social life and dream job in arbitration? So knowing all these questions, and I'm sure some of those questions were there in your heads at some point too. If you had a time machine and if you could advise yourself back then at the start of your ADR career, what steps, what strategic steps to take to get the best option in international arbitration, what would you tell to yourself? And maybe I would start with Dimitra.
Thank you very much, Barbara. I could not agree more with Andra and what she mentioned about having a mentor and how helpful this can be. And it's very important to be able to know that you can turn to this person for guidance when needed. Because it can be pretty tough out there. And sometimes you think you can make it alone, and it's true, you can make it, but it could be way easier if someone advised you in advance what steps to take and what the best, what the most efficient way would be. And of course, you can take part in mentoring programs like the ones that Andra mentioned, or you could turn to your professor and stay in touch with your professor, or even your employer, the partner in your law firm. Whenever I had questions of this kind, I would always discuss with more senior lawyers in law firm who were always willing to share their own experiences and show me different perspectives. So I believe it's very important to be open to discuss your concerns, and of course to stay in touch with your contacts and grasp networking opportunities. I personally found and met two of my future employers during such a networking opportunity. Of course, I did not follow up immediately asking for a job. I stayed in contact with them, also because I liked them as personalities. And then when I was in need, when I was interested to find a job or move from one jurisdiction to the other, I contacted them and I told them I take the liberty of attaching my CV, and if there's a position that corresponds to my profile, please do let me know. And this actually worked very well for me. I would advise to myself to try maybe also to publish more from the beginning, because I think I could take more advantage from research papers and my thesis, work that I had already done at the university. So you can just take full advantage of it and publish papers afterwards, and this is something that may also give you more publicity, so to say, and more exposure to the arbitration community. And some advice that I felt it was very useful when it was given to me, and that concerns more the everyday work and life in the arbitration field, was first how important it is to set priorities, because the workload can be a lot sometimes and you might feel a lot of stress. But if you set priorities and you see what task is urgent and what's not, I think this takes a lot of the stress away, and it shows a very professional way of handling your workload. And I also think, especially at the beginning of your career, that it's important to share your views, to share your ideas with the team you're working in. This way, you will show how valuable member of the team you are. And I think this is important because maybe younger lawyers feel more shy or more reserved, and they do not feel that they will make a mistake if they express their opinion on a specific case. And I don't think this is the case. I think it's very much appreciated by the rest of the team. And my last, so to say, advice would be to consider, of course, specializing in an industry that it might have practical importance. I think it's useful to be the go-to guy in a law firm the go-to guy when it comes to hospitality disputes or aviation disputes. This will also show that you are a valuable member of the team. Other than that, I believe that there's not only one pathway to reach your destination. There are many, and they're out there for you to explore. And of course, there's not only one destination. In arbitration, if one way doesn't work, you can work in law firms, you can work in institutions, you can work as in-house lawyers. So do not get discouraged at all. There are so many options out there.
Thank you so much. Sounds like a set of very useful tips. Lisa, what would you tell to yourself at the beginning of your career? What advice would you give to yourself?
I agree with everything you said, Dimitra. I guess if I would boil it down to kind of 3 tips, one that I did do, one that I did not do, and one that I did do but maybe not enough. I guess the first one that I did do was, if you are looking for firms to practice at a law firm for international arbitration, I would suggest to look for ones that actually have an international arbitration practice, rather than those that kind of practice or have arbitrations occasionally, because then you can really kind of develop and focus your career on that field, and it wouldn't kind of be left up to chance as to whether you are staffed on an arbitration. So if you are in the market for a law firm career, take a look at the ones that are specializing in the leaders in that field, and that's kind of the best way to develop your career. The piece of advice that I wish I did was to clerk if you have the opportunity to do so. I've heard only great things from people who have clerked. It's a great way to not just in the U.S. you clerk for a court, but you can also clerk for international courts. And this is just a great way to see what good advocacy is and what bad advocacy is. You can develop your writing skills by seeing what good writing is and what not so good writing is. And the one advice that I did do, but I wish I did more of, was just really develop your foreign language skills if you have it. I took Spanish and French in college. Those are really 2 of the major languages that arbitrations take place in, as Camila was saying. So if you have those language skills, continue developing them, take them in college, take them in law school, just practice using foreign languages, because an international arbitration lawyer with foreign language skills is just a huge asset in this industry, in this cross-border or borderless industry. So those are kind of my 3 pieces of advice for those of you looking to start your career in the arbitration field.
Thank you so much. Camille, what would you add to this list?
Well, my main piece of advice echoes a lot of what we've heard from Andra and Dimitra, too, is that networking and the ability to build your network is a skill that you can work on, that it's not something that is necessarily innate. I really went into law school thinking, okay, networking is you show up to a cocktail reception, you talk to the most senior person there, you get their card, and that's it. And that really isn't what networking is, or really what it should be in arbitration. Like Andra was saying, it's a very small field. We all tend to know each other, or at least know of each other. And so part of the challenge with networking too, and for me, I found I really needed to develop those skills very quickly, because as a solo practitioner, as I was mentioning before, that I didn't have very many people who could vouch for my abilities, vouch for my skills. So to some extent, I had to turn to networking for that. And that it isn't just going to cocktail reception, getting someone's card, adding them on LinkedIn, and never speaking to them again. That you really need to foster those relationships. So it's grabbing coffee, it's thinking about ways you can collaborate, it's preparing a panel, it's working on a report for a bar association, so that even if you tend to be more introverted as I am, that 9 times out of 10, I would rather stay home reading on my couch than going to a cocktail reception, that it's finding the ways in which you're able to build those connections and get people who are very willing to help and support you, but that you just need to kind of build their confidence in you and have them see your abilities. So I would say that's something, especially for the students, that you're really in a prime situation right now to work on those skills, that if you're going to these receptions now that we're opening up a little, challenge yourself to speak to, you don't need to speak to absolutely everyone, but don't just stand in the middle of the room with your classmates. That make sure you're reaching out to the attorneys, to getting to know people, because you never know who will become a mentor. The mentoring programs are really great for finding senior practitioners, but you could also find mentors in people who have 2-3 years more experience than you do. And they probably are a little bit more connected to what you're going through right now than someone who has 20 years of practice experience, whose legal education was really a different situation. And I guess kind of within that mentoring bubble too, one piece of advice that I did receive early on is to think about mentorship as building a board of directors for a corporation, that you don't just want one director, one person who's telling you, okay, you should do this, but you really want a diverse amount of people who can weigh in on your career and whose experiences might be similar to yours, but might be very different. They might practice in different jurisdictions. They might be a lot more senior than you. They might be at your same level, but just having a variety of perspectives really helps for developing your career and figuring out next steps. Every time you need to make a big decision, having that board of directors there to a certain extent can really help guide you.
Thank you, Camille. Sounds, again, extremely useful. And I think it's also a nice bridge with my question to Andra, because maybe you are yourself at the early stage of your career. So that makes you also, as Camille mentioned, a great mentor to the students who are now making choices, especially our 2S students, bachelor students, where to go next and how to infiltrate the international arbitration community. So from your perspective, what would you advise to those students and to yourself maybe from a few years back?
Thank you very much, Dr. Varvas. And I have to say, especially because I'm just at the earlier stage of my career, I have to also thank my co-panelists, because their advices are also very helpful for me. So I'm taking notes down. And for the students to us, you can always contact me on LinkedIn and, ask me any question that, if I can help you with anything. And for me, I had a very great time within the International and European Law Program. And it's always nice to talk about, my path afterwards and to talk to students. So if I can help with anything, you can always contact me on LinkedIn. And I guess if I were to tell myself something, I would tell myself, you never know. So apply for the job, apply for that internship, apply for that mentoring program, text that person on LinkedIn. I have to admit, I struggled a lot with making connections on LinkedIn, because I would always have anxiety over it and think that, what if the person will judge me, or what if I don't have all the qualifications that I need? What if I don't have all the achievements? And at the end of the day, it took me at least 1.5 years to realize that at the end, that it's important that you put yourself out there, that you try it out. Because after a year, I really do not look back and say, I'm very sorry I applied for that internship and I didn't get it. I would rather say, I'm sorry I didn't try. I'm sorry I didn't send my application because I was scared I wouldn't get it. Even if you get through the interview and you don't get the job, it's still important the fact that you had the opportunity to interview and to find out more about the job and to improve your skills and get feedback. So any kind of opportunity that you see and you think that this may be good for me, I would advise that you apply for it. Maybe you get it, maybe you don't get it, but you will not regret the fact that you applied.
Thank you so much, Andra. Very inspirational, and indeed, it's not that easy as we all think. And now I'm also realizing that for the past 2 years and even more, 2 years, we had a pandemic where networking was at a totally different level. So LinkedIn must have been one of the most important means. So well done, Andra, also for being so brave and for powering through. All right, so I would like to now give back the floor to Artemis, and you can decide if we open the floor to questions or if we go ahead with a more moderated discussion.
Thank you very much. I hope we will have questions soon. I know that students sometimes are shy, and I see that we have a number of students watching us via YouTube. They prefer this method, so I'm really looking forward to their questions there. We don't have any yet, so please don't be shy and ask any questions you want to our fantastic panelists. But if I may ask a follow-up question based on what you discussed so far. First, when it comes to networking, which is a big problem not only for students or young practitioners, but also for those who are not that young. I really like the fact that you highlighted that it is not just important to give your business card or say hello to the most senior member in the room, because it is not necessarily very helpful. So one of the questions that sometimes I ask from mentees, I'm also involved in a number of mentoring schemes, or students, is like how we approach these big names, which is quite difficult, and not only via LinkedIn, also in person, because there is this fear that I have nothing to offer to them. Really. So if I speak to them, it is going to be like a waste of their time. And I'm sure that all of you have the same thing. You will experience that when very young students, very young practitioners approach you, and they have the same feeling that I am introducing myself to her. She works in this fantastic law firm. She works at the ICC. She has her own practice. And what do I have to offer to her? I mean, and but perhaps it is also important for them to network among their peers, because at the end of the day, these are going to be their potential clients, the people who may recommend them for XYZ position. So I would also like to hear more your views about the human factor, the science behind networking, and if you also think that networking among people on your own level is useful or not. Who would like to step in? Perhaps.
I can jump in, at least on networking with people on your own level too. So one strategy as I was starting to do more networking was going to these events, as Artemis was talking about, and approaching very senior people was very intimidating. When it was easiest was when the arbitrator I was working for was there, so he could facilitate the introduction. But when I was on my own, what really was helpful was finding junior associates or other people around my level, because chances are I would have a lot more in common with them than with someone who was super senior. And just speaking with them too, to some extent, helped with my confidence. So it was like, okay, I can speak with people. We can engage in these topics, but then also they're working for people who are high up in their firms. So as you get to know them, they can start to facilitate these introductions as well too. So I would say there's definitely a huge value in getting to know people on your level or people with a few more years experience than you have, because I mean, they're going to be your peers eventually. And also you never really know where someone's going to end up. So could be that they're a law student today, but tomorrow they're the client that your firm is trying to, they're working in-house at the client that your firm's trying to sign. So it really, and also too, they see you grow up, they see your career journey, they really follow that, and can become quite close friends. So I would say there's a huge value in getting to know people on your level, and for approaching kind of the most senior people too, that having becoming friends with their star associate is really kind of a great way to have a bit of an in there at least.
Thank you very much.
I think it's when kind of networking up, so to speak, it's helpful to remember that these people are already there at the networking event. They're already committed to meeting young lawyers, and they got to where they are through networking and through mentorship in their own rights. And so, take with that in mind, you can approach people, you can ask them for advice. It doesn't have to be, a two-way street where you're offering something in return. In just the same way that we're doing this panel and we want to pay it forward to students because we were, not so long ago students ourselves. It's the same kind of mentality going to networking and talking to people who are more senior to you. And I think of it as, it's a two-way street because as they mentor you, maybe you go to work for them, you take matters off their plate, you make their lives easier as well. And so it's a mutual kind of exchange.
I completely agree with Lisa. And if I may add, the most interesting discussions I ever had with a little bit more senior lawyers in the field were not discussions about arbitration. At the end of the day, these are also human beings, and they go on vacation, they like good food. So the conversation that will break the ice does not have to be necessarily arbitration. Hello, I'm here to discuss about arbitration. You can just, they know that you come from a different country. They might be interested, about nice restaurants and nice ideas for vacation. So I think this is a nice way to break the ice in the beginning. And then they will ask you themselves questions like, what are you doing currently? Are you interested in expanding your practice towards this and that direction? So I think it's a nice way to break the ice this way. And with respect to networking with peers, with lawyers that are closer to our situation and age, I totally agree with Camille. I actually have still friends that I made during the Vismut when I was still an undergraduate student, and we stay in touch, and these lawyers are placed all over the world. And I think it's something that makes arbitration even more interesting and more exciting as a field, that you can stay in touch with these people. You have similar interests to share, and yeah, we should never forget the importance of socializing with peers as well, of course.
Thank you very much.
I completely agree with Dimitra that the most important matter is breaking the ice and how to break the ice. Camille touched upon something that I believe is very important, that you have to have something in common with that person. And sometimes you are the one to create the opportunities for yourself. And in this sense, I think for students, it should be very important to attend events and subscribe to newsletters, find out which events are organized in the field of arbitration. There are very many organizations out there, from Young ITA, Young ICCA, CARB, which all organize events in arbitration. And during those events, you should research a bit about the speakers and then send them a follow-up message on LinkedIn afterwards. Maybe not all of them will reply, but having that connection is a very important stepstone in building future networking and future relationships in the field. On that note, since Dimitra talked about the Vismut, I was a Vismuti this year, and I have to say that the Vismut is an excellent opportunity to create networking with people from all over the world and to meet up. Even though you compete against those people, at the end of the sessions, we always have these very nice 10-15 minutes conversations while the arbitrators are deliberating, and then you exchange your contacts on LinkedIn and you keep in touch. You never know where you'll end up next. I worked this year I had an internship for a law firm in Brazil, and actually one of the teams that I competed during the Vismut was a team from Brazil. So if I end up in Brazil, I will already know who to contact in the country. And I believe that's something very amazing about arbitration. In networking, in the sense of networking, I think the first thing I've done and the first experience I had was with the post-case coordinator, since I was also, and we were also contacting arbitrators in the field. And that was also a way to network with arbitrators and develop the project together and organize a project.
Thank you very much, all of you, for sharing your inputs and your tips. Thank you, very highly appreciated. If I may touch upon what Dimitra mentioned in the beginning about potential over-specialization in international arbitration, and I do have a feeling that perhaps here we have a common law versus civil law divide. I think that in civil law countries, we tend to build very long CVs. We want one LLM, second LLM, perhaps a third one, or a PhD, and then we start our career. Whereas my feeling, I don't know, is that in England and in the US, it is more like we finish law school and then we need to have hands-on experience. So I was just wondering if, from your experience, you think that we need this specialization in international arbitration, or perhaps it would be more useful, let's say, for the students or the young practitioners to have a diploma in engineering, in construction, in energy law, or in a specific sector, but not in international arbitration. Who would like perhaps to go first?
Give it a try.
Thank you.
I think if you already have an interest in engineering, certainly that's a very great asset to have. I wouldn't recommend just getting it for the sake of specializing. So I'm coming from a common law jurisdiction, so I guess we'll modulate it to that experience. But I don't know if it's necessary to specialize in one type of arbitration, depending on if you want to go to a more general firm or a specialized firm. So if you want to go to a specialized firm and you have an engineering background or a damages background, which actually can apply to multiple arbitrations, a mathematical head, that can be very great as well. It's a fine idea to specialize. But it's fascinating just being on different cases and getting whatever comes to you and learning about the industry that you have to learn about to do well in a case. So I've done a pharmaceutical arbitration, I've done the construction arbitration, I'm in oil and gas arbitrations, liquefied natural gas in particular. And all of them are very interesting, and it really just comes down to, do you know how to handle an arbitration procedurally? Do you know how to write well? Are you a good substantive advocate? And you learn all of the facts as you go. And it's actually really, really fun to get to know different industries and adapt to the needs of a specific case. So my advice would be, if you already have the pre-existing interest in a particular field, you should continue to develop it. But if you're more of a generalist, that's fine as well, and you'll be able to find good work.
Yeah, for me, I'll echo a lot of what Lisa said, though, with keeping in mind that we're both coming from the same jurisdiction, from New York. One description that I've heard is that kind of lawyers, especially in litigation arbitration, are mini experts in a lot of different topics. So with each new case, you kind of become an expert in that area. And one thing I would warn against, too, is if you have the interest, as Lisa was saying, in engineering, in a certain area, that's great. But being a generalist, I think, gives you the flexibility, especially early on in your career, that you can potentially develop a specialization later on. But I'd keep an open mind, at least in the initial stages, because you can explore and you can see what interests you. If you're really passionate about construction disputes, that's something you can explore if you're passionate about energy. But if you do that too early on, you risk cutting off an area that you're super passionate about.
If I may, I echo all the opinions, and I completely agree. And so to say, what I had in mind when I meant over specialization is I get this feeling that younger arbitration practitioners, they feel that they need to focus a lot on procedural aspects of an arbitration, to know everything about joinder, about pathological arbitration clauses. And that's, of course, very important. It's sort of a given when you are involved in an arbitration, but it's also very important to keep an open mind, to learn and grasp information regarding all these different industries, and be able to create a convincing story for your client. And that's what I believe, that we need to keep an open mind and also be passionate to learn about all these different industries, and not focus on the technical, procedural necessarily aspects of the arbitration as such only.
Thank you. Thank you very much. Andra, would you like to perhaps to comment on that based on your experience, if you think that your master specialized in international arbitration is important for your next career steps?
I believe that it is definitely very important to have a master program. And if you want to work in arbitration, I would say that you should have taken certain courses in international dispute resolution and arbitration. Now, since I'm in the process of applying for jobs in Europe, I could point down to that and see which are the requirements in the field at the moment for the internships I'm applying. I do see a tendency that law firms do ask for specialized LLMs. And especially if you want to work for one of those big law firms which only do arbitration, I think it's necessary for an internship that you do have a specialized LLM and you've taken different courses in arbitration. I've seen some job offers which say that it is considered an advantage, but given, and I do agree with Dimitra on the fact that more and more young practitioners, and there are more and more master programs in arbitration which young practitioners do tend to take, and you do have to keep in mind as students that you will have to compete with those professionals who studied arbitration for a year and which were specialized in arbitration. I believe for maybe the beginning of your career, especially if you just graduated from your bachelor and you are going into your master's without much experience, I would say that from the job requirements that I see now for internship, it is considered an advantage to have a specialized LLM.
Thank you. Thank you very much for sharing your views with us. Thank you. And now I see that we have a number of questions that came to us via YouTube. So I will focus on these questions. And the first one is addressed to Camille. So the question is about how your typical workday looks like. So I guess if you could elaborate a bit more on your duties. So what is your everyday schedule? Thank you.
So I think I'll give the very lawyerly response that no day looks exactly the same. But for me, what tends to fall largely within my duties, I tend to do a lot of drafting. So I'm aiding arbitrators in preparing awards for appropriate sections, reviewing submissions. So if a party's turned in a 500-page memorial, it's kind of pulling out what's most important of that, what sections they really need to focus on. Though obviously the arbitrators I work for read the entire memorial, it's just kind of narrowing it down the most important issues. And it also can be drafting a lot of memos. So if there's something that the parties have argued and the arbitrator isn't entirely clear on the law that they're choosing to apply, they might ask me to look into it, to pull cases, to give summaries of the cases, of the case law being cited, especially with common law parties too, since I know for civil law, case law is not quite at the same level of importance. And then also there's kind of an organizational aspect too. So there's managing documents in terms of exhibits. In some cases, it'll be almost 1,000 exhibits, and the arbitrators decide they want to cite something that they know is in one of those 1,000 exhibits, but they can't quite find it. So I'm the one who ends up doing the digging to find that, managing communications with the parties. At times, it's also figuring out tech issues too. I think that's one of the advantages of kind of younger tribunal secretaries too, is that a lot of us were raised in the digital age, that we understand how to use the various technologies too. So if there are issues that come up, we're the ones who end up giving that tech support to arbitrators, regardless of our background in tech or not. So it's really a mixed bag. And then on top of that too, I do other aspects. It's not necessarily paid work, but it's ways to kind of build my profile within the community. So it's speaking engagements and working on articles, working on publications, because as a solo, you rely on what business your clients can bring in too. So that's the other aspect of my work as well.
Thank you. Thank you very much for elaborating on various aspects of your work. Thank you. And I particularly like the part about the hundreds of pages that sometimes the parties submit, and they take it for granted that the arbitrators and the tribunal secretaries will be able to digest everything. And I particularly like the fact that they usually start with thanking the parties for the material they sent to us. And I'm a bit worried, is this an honest thank you, really, when you send them hundreds of pages? But at least now we have the Greener Arbitration Initiative. So we are trying not to destroy all the forests of the Amazon. Thank you very much for that. And it is true that I see that besides your legal duties, you also need to increase visibility of your profile when you're working as a solo practitioner. And thank you for highlighting this. It is another important aspect. Then we have a number of questions related to CVs and cover letters. So if I may try to summarize them to a certain extent, there is a problem. Most students know that they need to have very good grades, and they need to have languages if they want to work in the international arbitration field. But besides all these, what do you think that can make a candidate as a standout? What is the one thing that you can see on the CV of a candidate for an entry position, and you will say, this person deserves an interview with us? Thank you. Anyone who would like to jump in?
I can maybe share my view on this. I believe the presentation of yourself through the CV or the cover letter is important. So the way you organize your thoughts in a cover letter, the fact that you are concise and you give, you focus on the information that you want to shed light on, it's important. And the way you organize your thoughts. So it's your first contact with someone who is considering hiring you. So the way you present yourself, I think it's a pretty important factor to be as concise and make sure that you highlight your strong points. I think this is something that is taken into account.
Thank you.
I'm happy to share some CV tips, and just you should take it with a grain of salt. Every jurisdiction is different, every job is different, and may have different requirements. But as a general matter, I think what stands out on CVs is action words and numbers. So I've heard. So if you've done something, say exactly what it is you did. You increased participation in a program by 50% or something like that. In more action words specific to kind of your role. And for the most part, I would recommend just keeping everything on one page. As a student, you really shouldn't have more experience that needs to take more than one page. Tailor it to the job you're applying for. So don't just have the same CV for everything. Really kind of think about what stands out more for this job. And really, just don't don't stress too much about it. The CV represents, everything you've done, and this is, you on a paper, but, the interview is just as important. The cover letter, which talks about your interests and your background and your experience, is also just as important. And so that's kind of my 2 cents about CVs.
Thank you very much. Yeah, would like to share your views with us.
And I guess, yeah, just to pick on the point that Lisa mentioned about tailoring your resume to make sure that you're reading the job description. So if there are tasks or duties of that position that are really specific, and you have specific examples within your work experience that highlight why you would be good at doing those certain tasks, it can help to echo the language in the job posting. So I would think about that, and really, Lisa and Dimitra really covered it all. Try to stay on one page, and yeah, use action words too. But yeah, beyond that, nothing too much to add.
Thank you very much. And Andra, would you like to share with us your perspective from a young candidate who has applied and has been applying now? So what is the thing that you think that you do it right, and perhaps a mistake that you identified and you're trying to correct it or modify it? I mean, for me, it was very difficult to stick to one page. That's the most difficult part for me.
I agree. That is the most difficult part for me as well, because I want to list everything that I've been involved in, all the projects, all the competitions I took part in, and the skills I have, and it's just impossible to do it in a page. So that's something I'm still struggling, why I still haven't learned it. I can now stick to the cover letter with one page, but with the CV, it's still a work in progress. I believe that it's important to tailor it. Indeed, as Lisa said, to tailor it to the job, and see in the job description there are certain keywords, and then use those keywords in your cover letter. Because sometimes for the UN, for example, when you apply for a job, they actually, the first person that reviews your application is not really a person, but a machine. And they look for those key requirements, and they compare your cover letter with your their job requirements and entry requirements. So I understand, and maybe my panelists know about this as well in the field of arbitration, maybe, that it is becoming a very common practice, because there are so many applications, for students to actually get reviewed first by an AI machine, their applications. So it's very important that the words that are used in the job descriptions, you also use them in your applications. As a tip, something that I've seen it works for interviews is actually to send them an email afterwards and thank them for the interview, and let them know that if they have any other questions, they can contact you. And it's just like a wrap-up message. Thank you for having me. It was a very nice pleasure. And even if you don't get the job, they will remember you, because that's something extra that not a lot of people do. And just in general, check up. Sometimes, your application just be missed because there are so many applications. You can always check up, even if you don't get a reply after 2 weeks. You shouldn't say that, yeah, I didn't get it. Maybe they just didn't have the time. Didn't have the time to review it. So always keep into contact, and it really shows great communication skills. That's how during the pandemic I managed to get an internship, because it was very hard, and I was calling them and I was always checking up, and that's how I managed to get the internship.
Thank you very much, all of you, for sharing tips. And now I realize how many mistakes I've been making in the past. So thank you very much. I am learning a lot from that as well. We also have one question about a common thread or a strategy that you apply in your practice when you need to work in entirely different sectors. So when you have one case, let's say gas and oil, and then you have a case in an entirely different field, what do you do? How do you familiarize yourself with the new field? Do you seek help from colleagues who may be familiar with the other field? What do you do? Lisa, would you like to kick off?
Yeah, happy to. I guess one good way to learn about the industry is just to read the news, to look at industry papers, but also just as you're looking at the facts of the case, you find yourself learning about the industry as you go, and that's the natural part of building your case. And so the key kind of the core skills that you'll develop as an arbitration lawyer, how to advocate effectively, how to present fact witness statements, how to liaise with experts, all of that you'll learn kind of as you go. And so there's no kind of need to become an expert in oil and gas right away before you even take on the case. As you learn the facts, which you'll do in any part of the representation, you'll be more and more comfortable. So my recommendation is just to do the work that you're assigned to do, read the news, read the industry papers, and et cetera. I like to set up news alerts for my new clients as they come in, so that we can kind of bring up recent news of relevance to them whenever we have a client call. They really appreciate that as well. So that's another way to kind of stay apprised of the issues as they come up. But yes, talk to colleagues and do all of that due diligence, but also don't stress too much about it, because if you are going to be a lawyer in an arbitration case, you'll come to learn all of that as part of your representation.
Thank you. Thank you very much for sharing your views with us. Thank you. Camille, would you like to have the floor?
Sure. So for me, I approach this from the perspective that really the council has done most of the heavy lifting here when it arrives to me. So I guess my perspective would be a little bit different from Lisa's in that regard. Just because the expectation at that point is the council has laid it out for the tribunal well enough that hopefully we should be able to understand everything completely. Of course, that's not always the case. But really, one of the advantages with arbitration, too, as we speak about the need for publications, too, is that we tend to be a very prolific profession in terms of writing. So chances are, if there's a topic that comes up in your arbitration, someone has written an article about it at some point. So it's really using those resources, checking out GAR, checking out Colwar Arbitration blog to just see, even if there's a tiny snippet that can help with your understanding and help get there, there's probably something out there. Someone has probably addressed it. And of course, speaking with colleagues, this is kind of where peer networking works out too, because you might have someone at another firm who's covered a similar matter or who's working on a different matter. So having those resources too can be really helpful just in terms of understanding fields that you haven't worked in before in general.
Thank you. Thank you very much for your tips. Thank you. Dimitra, would you like to share your views?
I echo everything that has been mentioned by Lisa and Camille. At the moment, I'm sort of the same like Camille. I do not have to delve into an industry myself, because the work has been done by the arbitrators who draft the award, and we just scrutinize it, or the work has been done by the council whose submissions we are reading. And there I get all the information I need for the specific sector. But when I was working in law firms, I remember that I used to discuss a lot with my colleagues when an issue came up and I knew that they had tackled such an issue before. And I also used to Google a lot. So I would find all the articles and all the information, especially the first time I was involved in a construction case. I was also Googling every technical term I would encounter, because I did not know what it means. And also my mother tongue is Greek, so all the more in English, there was no chance that I would know the term. So internet and all this information that is out there was very, very helpful for me.
Thank you. Thank you very much for sharing your input. Yes, and not only we don't only need to Google when it comes to terms, but also when it comes to pictures, when it comes to construction arbitration. I think that pictures are also very important. And I felt happy when I was with native speakers and they didn't know what we were talking about either, because they were also very junior. So I'm like, Okay, so it's not just an issue of knowledge, it is also of the language, but it is also a broader issue when it comes to certain sectors. So thank you very much, all of you, for sharing your tips. If I may expand a little bit more on something that Lisa mentioned before, when you identified one of the issues that are very important nowadays, you mentioned the balance between courts and tribunals. If I may move a step forward, we observe nowadays proliferation of commercial courts, English-speaking commercial courts. And there is this anxiety on behalf of certain young practitioners. Are we going to have enough work in the international arbitration field, or are we talking about these systems that they can coexist in a harmonious way, or we think that they will be able to replace, to a certain extent, arbitral tribunals in certain jurisdictions?
Thank you for that follow-up. That's a really interesting question. I hadn't considered it before. I think that the draws of arbitration, namely being confidentiality, speed, privacy, and all of that, will still be attractive to commercial parties, whether or not we have commercial courts also developing as well. I think for the most part, what I'm seeing is as deals form, you know, there's a commitment to doing arbitration because it's confidential, and in a lot of deals, arbitration is still more appropriate than courts for that reason. If there's, you know, parties from two different jurisdictions, for example, it's really hard to pick which jurisdiction will have the courts be in charge of deciding disputes. And so I think there's going to be kind of a harmonious balance between commercial courts dealing with, you know, more domestic commercial disputes, and tribunals still continuing to handle the cross-border commercial contract disputes.
And I guess to add to that too, one of the really attractive features of arbitration is, for most cases, the ability to choose your own arbitrators, which isn't necessarily going to be present within those commercial courts. So completely co-sign with what Lisa said, and I'd say that's another aspect too, where parties choosing between arbitration and to go to a commercial court, if the clause does allow them to appoint their own arbitrator, even if it's a 3-member tribunal, they might choose to go that way as opposed to court, where you might be rolling the dice about who you're going to get.
Thank you.
Absolutely. I agree that arbitration gives this flexibility to the parties to pick their own arbitrators, to decide whether they want an expedited procedure or a longer procedure, which is something I think you cannot decide necessarily when it comes to courts. You can decide the language of the procedure, the applicable law, but also you have the opportunity to basically, under the New York Convention, enforce the award wherever in the world. And I think this is a very big advantage of arbitration as well compared to courts.
You can't decide your award issue date for courts, but you can do that with your arbitrators, and you can actually have I've seen a contractual clause where they require the case to go to hearing within 6 months, for example. So that's a unique aspect that you'll get in arbitration.
Indeed. And actually, from my experience, I've seen also fast track arbitrations where even when drafting an arbitration agreement, the parties agree in advance that they want the dispute to last this long. So the flexibility is really immense. And I think this is a big advantage.
Thank you very much for sharing your views on that. This is very encouraging. And I think that it is also very encouraging to see that Andra is very much in love with international arbitration, despite the fact that you belong to the generation that during your studies, you've been taught and you've been come across quite a strong criticism against arbitration, more when it comes to investment arbitration, of course, which is a pity, but then it's a whole new topic and we can discuss for 2 hours at least about this. So I'm glad to see that you are still in favor of international arbitration and you acknowledge its positive aspects. And yes, please, you have the floor, Andrew.
Yes, indeed. And I think that all my panelists touched upon this issue that one of the most important things about arbitration is the fact that the parties have the ability to choose who is arbitrating their disputes. And especially because in arbitration, there are so technical issues such as energy arbitration, construction arbitration, it is important that those specialized arbitrators actually have expertise in that issue and have experience in dealing with disputes of that kind. Because I believe that even in the courts are specialized as commercial courts, since they are in only one jurisdiction, I'm not sure how many cases would they get, because they would still be linked with a certain country. Whereas in international arbitration, because it's not necessarily linked, it is linked in terms of the seat, but the proceedings are so international. I believe that it does foster the expectations of the parties better. And in relationship to confidentiality and transparency, since this was also touched upon, and I know that nowadays there is a discussion about how should this be tackled. Should arbitral awards be more transparent? Should they be confidential? And the ICC, I think it's one of those institutions who is tackling these issues very well, since they do publish the awards, but the parties are not disclosed. So people can get, and the community can get knowledge about it and can understand how these issues are tackled. And I do believe that as long as the confidentiality and the name of the parties are not disclosed, it is convenient and it doesn't infringe upon the advantages of international arbitration.
Thank you very much, and thank you for touching upon two aspects that can lead to a very long discussion. What do we mean when we say transparency and confidentiality? And there are also some scholars that they adopt the view that we are almost in a transparency paranoia era. So this is where we live in, but this is again a very long topic for a very long discussion, and it would be great to have this one day all together. And thank you for giving us this idea. Thank you very much for that. If I may, I would like to almost close this fascinating for me session, and thank you very much for that, with our parlor game, which is inspired but not created by Marcel Proust, the French novelist, who believed that in answering a couple of questions, some of the questions that you will listen to in a minute, individuals reveal their true characteristics. So it was in 1886 when Antoinette Forêt, the daughter of the future French president Félix Forêt, asked her childhood friend Marcel Proust to fill out a questionnaire in a book titled Confessions, an album to record thoughts, feelings, etc. So now I'm turning to you and I'm looking forward to your spontaneous answers. So I will start with Lisa. Lisa, what is your favorite virtue?
Favorite virtue? Probably just communication, I guess. I don't know if that's a virtue, just openness with each other, which I've seen from all of you on this panel, just a receptiveness to new ideas. I think that's a really underrated but really valuable virtue.
So true. Thank you. Thank you very much for that. Camille, for what fault do you have most toleration?
Sorry, for what fault?
You have most toleration.
So I would say probably tardiness, I guess, or delay, just because I mean, by virtue of having a lot of deadlines, I have a lot of delays, but also coming from a Latin American household, we often run on Latin American time too. So just having a tolerance for someone coming late, for example, that I usually don't have too big an issue with that, though I tend to be pretty timely.
Same here, but I agree. So I saw the same feeling. I agree. I'm moving to Dimitra. Dimitra, what is your perfect idea for happiness? Of happiness.
Perfect idea of happiness. I would say family, friends, and a cup of coffee. Very important.
Thank you. Thank you very much. Then, Andra, what is your greatest fear?
I guess that would be having regrets. I think my biggest fear is having regrets. I realized it quite recently that I do have a fear of having regrets, and for this reason, generally, I've tried being more active and taking opportunities and just enjoying.
Thank you. Thank you very much. Camille, which living person do you admire most?
So for me, it would be our U.S. Supreme Court Justice Sonia Sotomayor. So she's the first Latina justice to be on the Supreme Court ever in U.S. history, and she's someone who's a very hard worker and someone I really deeply admire.
Thank you. Thank you for this answer. Then, Lisa, what is the quality you most despise in human beings?
I'm gonna give my New Yorker answer and say people who stand on the escalator when you're on the left when you're trying to go around them. But my serious answer, I guess, would be maybe on the converse of communication, which is just, I don't know, flakiness. But my New Yorker answer, I think, would be the slow walkers and the not conscientious walkers.
I agree. That's a great answer. Thank you for that. Thank you. Andra, which words or phrases do you most overuse?
I have a phrase in Romanian, and in Romanian I say everything, totul va fi bine, which in English is translated everything will be all right. I think in Romanian it does have a deeper meaning, because when you say that, you have this feeling that no matter, you know, what happens now, there is always like for a reason, and you are going on your own path and everything will be fine in the end, and you need these experiences to grow and develop. And I think I also in English, I don't really know, but so I feel like, yeah, everything will be fine is something that I overuse. And during my internship, I was really well known for it.
Thank you. Thank you very much. It's a very nice answer, really. I will try to adopt it. Although the English version, because the other one is going to be quite tricky when it comes to pronunciation, but you will teach me how to do this. Then, Dimitra, what is a sound that you love?
Oh, that's easy. The sound of the waves in the sea.
Very, very nice. And now the same question to all of you. What is your favorite motto in life? Who would like to go first, really? It's up to you.
I guess I don't know if you can see, but the whiteboard behind me says "Not my circus, not my monkeys." It's actually a leftover from my old office mate who drew it and then moved to our San Francisco office. But in his kind of busy career and very stressful job sometimes, it's good to keep in mind, you know, just take care of what's, you know, your responsibilities, but otherwise, you know, relax, have a good time, and just be happy.
Thank you. Thank you very much for sharing this. Thank you. Thank you.
Maybe I can share something that I think mentioned even before, that for me it's delightful that there are many pathways to reach a destination. So there's no right and wrong. And these pathways are out there, and I'm excited to explore them.
Very glad to hear that. Yes, very inspiring. Camille, what about you? Your favorite motto?
I think the first one that came to mind was actually really similar to Lisa's, which is a phrase that my mom repeats a lot called OPP, other people's problems. So it really is kind of the same vein as Lisa's, just focus on your own problems. Don't necessarily try to take on other people's problems too.
Wow, thank you. Thank you very much. Thank you very much. And a big thank to your mother as well for that. This is something we all need to adopt at some point in our lives. Thank you for that. Andra, would you like to share your favorite motto with us?
I think my favorite motto, and the first one that came into my mind is whatever you do, do it with passion. And in every situation that you are in, try to take the best and enjoy. But now that I'm thinking about it, I think the one that I'm following now is wherever you go, bring a light with you. And that would mean that in every situation you are in, try to help the ones around you and try to work together and bring something meaningful and do something meaningful.
Thank you. Thank you very much for everything, for this very, very inspiring conversation for me and for all the participants. Really, thank you for making the time to share your experiences and expertise with us, but also these more personal views that they can make a difference, because we don't only have brilliant lawyers, international arbitration lawyers, but we also have human beings. And it was an opportunity to meet you a little bit better. And I truly hope that we will have an opportunity to meet in person before too long. So thanking you wholeheartedly. I wish you all the very best, a wonderful period ahead. And again, a big thank you from all of us. Thank you.
Thank you so much, Artemis, for the organization and everyone who helped to organize this panel. It was our pleasure.
Thank you.
Thank you very much. It's been a great conversation. It's been great to get to know all of you too.
Thank you to everyone listening, and feel free to reach out to us if you have any questions.
Yes, thank you very much. And thank you to my co-panelists. It was a pleasure hearing your stories.